Thank you, Mr. Chairman, members. Craig Eiland, representing Texas Trial Lawyers, and myself and firm individually against the bill as currently drafted. So what I want to do.
So Craig, just for the record, you're here on behalf of the Trial Lawyers
Association,
and you're against the bill.
And I'm against the bill.
Okay, all right.
So what I want to do is walk you through how a trial is going to occur under this bill and some problems that I think are going to happen, especially with insurance coverage. But first, I would like to take a look on page 1 under the definition of accident. And it says an accident means an event in which a motor vehicle, or I think we need to say commercial motor vehicle for this bill, comes into contact with the person or object. And so what happens when an 18-wheeler veers into my lane, I try to avoid that 18-wheeler, and I hit the embankment or the wall and damage my vehicle? Under this definition, that wouldn't be an accident. So I think that needs some work. So now let's go over. So now we're going to start the trial. I filed a lawsuit against the driver and against the employer, claiming that the employer failed to supervise, negligently hired, and negligently entrusted the vehicle to the driver. Okay? I'm not alleging that they loaded the pipe incorrectly, because I've been told that that would be a direct action and that you'd still have that cause of action. I'm talking about negligent supervision, negligent entrustment, and negligent hiring, which you kind of discussed in the TXI case. So that's my case, right? So first, this bill right now says 2 years. We're going to expand it to something, or I say 10, because we have a 10-year statute of repose for home builders, for example, and other places. So 10 seems to be a reasonable number to go back. And however far you let me go back in digging into the company's actions, I think you should be limited on digging into my lady's medical history and my lady's social media history. Because if it's good for one side to limit the discovery and limit the digging, it should be good to the other. The second is, and I know Mr. Smith raised this, so pick a number, let's say 10 years. I'm in deposition, and you asked the safety man a question. He starts to answer. His lawyer is going to say, don't answer that beyond 2 years. Don't answer that question beyond 4 years. Don't answer that question beyond 6 years. So it's not just about documents, it's about testimony. And then what if I gain evidence from other sources, from filings with the Federal Motor Vehicle Safety Act sources that go beyond whatever I get from Texas? Can I use that? Is it admissible into evidence? Is it admissible for impeachment? I think we need to address that. If I obtain evidence outside of this discovery allowance under the bill, but it is evidence that's proven up otherwise. So how are we going to handle that? But now, so we go through discovery. The first thing that I have to do is the defendant's going to file a motion for summary judgment on negligent entrustment, negligent hiring, negligent supervision. They haven't made their decision about respondent superior yet, because they may or may not have to make that decision. So first, the judge, we have our hearing. I say, Judge, here's my evidence. He says, okay, I'm going to deny the motion for summary judgment on negligence. I'm going to grant the motion for summary judgment on gross negligence. With me? So my claim against the company is now just for, so I got the driver, no question about that. My claim against the company for negligent hiring, supervision, and entrustment is just negligence. The gross case is thrown out. Okay? So now there's no need to have a phase 2, because there is no case for punitive damages against the employer, because summary judgment has been granted on gross negligence. So now I've got the employer and the employee both on a negligence case ready to go to trial. And so what this says is before voir dire, the defendant employer can stipulate the course and scope, right? If they stipulate the course and scope, the bill says that the action against them is dismissed. I know Mr. Breslin talked about this. I say if that is going to remain, then that should be abated. Because if you dismiss, then that can never be revived. Because if the judge refused to grant the motion for summary judgment on gross negligence, right, so I still have that active case, now we come into the trial before voir dire, they stipulate the respondent superior, and so the judge dismisses those causes of actions. We're 2.5 years from when it actually occurred. I win the first phase of the trial. Now I go to gross negligence, and I'm supposed to try a case on an action that has been dismissed a week earlier. That's why I think that those, if you're going to keep that, that should be abated as opposed to dismissed. But let me go back to my scenario. So the judge said no summary judgment on negligence of the employer, no summary judgment on the defendant driver. Summary judgment on gross negligence, so that's out. We're before voir dire. Defendant says we stipulate the course and scope, right? So now the claims against the employer are either abated or dismissed. They are still there for respondent superior purposes, I believe, is the intent of the bill, where their name is still there, with still defendant driver and employer names on the jury form. But, so they stipulate the course and scope. Does that mean that before they stipulate the course and scope, make sure you understand, the claims for the defendant driver are covered under the commercial auto policy, right? The claims against the company for negligent supervision, negligent hiring, negligent entrustment is covered under the commercial general liability policy. So I got one lawyer over here on the CNA auto policy. I got another lawyer over here for the company on the CGL from AIG. So now that the gross negligence claim is gone, we're in trial, we're about to go to trial. The commercial general liability policy goes, hey, all I got to do is stipulate the course and scope, and my policy's gone, and I can go home. Unless there's another defendant from a multi-car pileup. Then what do? They stipulate the course and scope. The defendant gets the claims against him dismissed as to me, but what about the guy that got rear-ended first? My lady stopped at the stoplight, a car rear-ends her, and then another vehicle rear-ends that vehicle. So if they stipulate his course and scope to me, how does that work? If that company on the CGL policy is dismissed for negligent hiring supervision, I think that's I don't know how it's going to work under this bill. But now, the employer stipulates the course and scope, that policy is gone, right? It's no longer at risk under this bill because that is dismissed. But what's the auto policy going to do? The auto policy is going, wait a minute, this guy was deviating from his course and scope of employment. I don't care what the stipulation says. There's no coverage under our policy so we're going to defend under reservation of rights because this guy was coming home from work. He stopped at the bar. He went to a movie, and then he came home afterwards and had an accident. They can stipulate all they want to about course and scope for their respondent superior stuff, but we have a auto policy that tells you when you're in course and scope, and it has nothing to do with what their stipulation is. And then I'm going to try to put on facts about that at the trial to try to, get them in course and scope somehow. The judge says, Mr. Eiland, that issue is determined. Course and scope has been stipulated to by the defendant. There's no longer an issue in this trial. It may be in a coverage case later on when they deny coverage, but that's the problem with throwing out the defendant when there is a viable cause of action against them for negligent hiring, negligent supervision, negligent entrustment. You're allowing them to get rid of an insurance policy that could satisfy the damages if a jury found 50% on the defendant driver and 50% on the company. That's why we have companies there, or comparative statute, Chapter 33. And now we're just going to toss them out along with an insurance policy which could be used to satisfy the injured victim. So I think that is a problem. Next, and I know this has been talked about, so I'll touch on it lightly. We're taking a piece of the medical malstatute that is voluntary, right? Voluntary, and we're making it mandatory. And only for people that cause a lot of damage. And now that there is no rebate of the money, why would you do that? Why would you allow a defendant who caused damage to a paralyzed woman, the jury gives her $2 million of future damages, the judge says, okay, I'm going to give you $100,000 a year for 20 years. After 2 years, she has something go on in her life, and her medical bills skyrocket immediately. She's got $2 million that should be available to her, but because the defendant really wanted to get her, right, after just for meanness or no reason or meanness, or to sell another insurance policy to themselves, here's a lady with a $2 million judgment who has no access to her money to pay her bills. For what reason? There's no, they don't get the money back later on. It's just, there's no reason to do it. And another issue here on page 7, this is a problem that if you're going to stick with future payments, you got to fix this. On line 16, page 7, the number and amounts of future payments shall correspond to the evidence regarding future damages presented by the claimant. Okay? So I put on a future life care plan of $10 million for my lady, right? The defendant comes in and says, no, we think that she can be adequately taken care of with $2 million. Okay, so the jury's got to weigh those two or somewhere in the middle. They come back with $2 million. And then the defendant, just being mean and spiteful, comes in and says, Judge, we have to pay $2 million, but we want to buy an annuity and fund that $2 million. And the judge says, okay, well, let me look at Mr. Eiland's life care plan. That's $10 million. How does he comply with this provision of he shall correspond to the evidence regarding future medical damages presented by the claimant? I mean, I presented $10 million and a whole different theory of how she should be taken care of. The defendant presents $2 million, but yet the judge has to fit $2 million into my $10 million. That's going to be, and judges will hate this because it only takes one instance to hit the papers of the lady getting a $2 million judgment, but the judge only giving her $100,000 a year to get that judge off the bench. He's only going to be doing exactly what the legislature told him. So I think that's problematic. And then I just think it's one thing I hope that we see between now and whenever the substitute comes out is all of these Court of Appeal cases where 403B has been misapplied and judges are either letting in prejudicial evidence or keeping out relevant evidence. Because what we are doing here in this bill is saying not just the trial court judges of Texas, and not just the appellate courts of Texas, but the Supreme Court of Texas is incapable of determining 403B and when evidence is too prejudicial to let in, or when evidence is not relevant for some reason if it's a photograph. So they can decide 403B relevancy on commercial plant explosions, and they can decide 403B on commercial disputes, but they can't decide 403B in commercial vehicle accidents regarding photographs. I mean, if they're capable of doing it, they're capable of doing it. So I don't know why we want to slice and dice and tell judges they're not capable of making that decision. But if you do make that decision, I think you're right that, I mean, the horrible photographs of the decapitated people come in, you know, and every other photograph comes in, as long as you have a sponsoring witness. I think that's it. Yes, sir, that's it.
Thank you, Mr. Eiland. I appreciate it. I'm going to reiterate to you what I just said to Mr. Bresnan. Get me your changes, if you don't mind, in writing. Of course, we've been taking notes and look forward to talking to you about it, but I'd like to see them proposed in writing.
Yes, sir.
Yes, Representative Johnson.
Thank you, Representative, for coming today. I want to explore with you an aspect that you touched on about commercial liability insurance. And, Mr. Chairman, a concern that I have about the shifting of gross negligence is kind of go back and touch on this, because I think it's really important, that all commercial liability insurance policies, they do not cover gross negligence.
Correct.
So what you're doing then is you're going to force a defense attorney into a position of how do they protect their insured client. Because if their insurance policy does not provide coverage, well, then the trucking company themselves becomes liable for the damage, correct?
Right.
And so this is a big vehicle for carriers to deny coverage to their insureds, because what we're doing is we're shifting a covered claim that's under ordinary negligence to an uncovered claim under gross negligence, right? So now what's happening is, instead of all these companies that have paid all this money for their general liability policy, all that coverage is going to be voided under these fact patterns.
Right, and you could have a conflict. Let me give you a world example. You have $100,000 on your auto policy, on your commercial auto policy, but you've got a $500,000 commercial general liability policy, and you know that there's $1 million or more of damages, right? Well, the company, the trucking company, or just the commercial vehicle company, they don't want to get rid of this $500,000,
Right.
because if the damages are more than $100,000 on the auto policy is going to pitch their money and say bye-bye, good luck paying the rest of the money. And the owner's going to want to say, well, maybe they'll hit me for part, maybe hit my CGL policy for part of the damages, and maybe that'll pay for part of it. But the commercial general liability lawyer is going to be telling him on the policy he has a duty to cooperate, and the employee's in course of scope. You've got to stipulate. He goes, well, he was in course of scope, but I'm not stipulating anything because I don't want you to go away. I want to keep this money here available to pay a judgment in excess of my auto policy. And so...
Right. Don't you think that puts the defense lawyer in an ethical quandary between insurance company and the commercial the company that they're representing? Is because, to your point, if they exercise this stipulation to shift the ordinary covered insurance claims to a gross negligence standard, by doing that, they're voiding the insurance coverage that company has, and they're exposing that company to direct personal exposure because their insurance policy is void. Right?
Right.
Yeah.
So,
Representative Smith.
Thank you. So along those lines, though, it's been represented to us that there are several states, about 12, that do not have the enabling torts of negligent entrustment, et cetera. Okay? And so, I mean, they still have this circumstance, though, with regard to the coverage that comes up. But have you looked into how these states handle that particular dance that she's talking about?
No, sir.
Okay. Because if we did away with negligent entrustment, just
Negligent hiring and negligent supervision.
right.
Do you really want to make that the policy of the state of Texas, that we're not ever, because that's what the bill does. The bill says, if you stipulate to course and scope of employment, the policy of the state of Texas is we do not care if you are negligent in your hiring of this driver who just caused serious damage. We do not care if you were negligent in supervising your employee who just caused serious damage, because you can stipulate and be scot-free. Now, if you're gross negligent, we're going to give the chance for the jury to hammer you. But if you're just negligent, you're okay. I don't think
I
that's
guess
the
I'm
policy.
just curious though about how these states handle that, because I wonder, are we saying that California, for instance, does not have negligent entrustment, right?
We got a whole lot of other stuff.
I can't imagine that they don't have negligent entrustment. So anyway,
I would trade their laws most likely for our laws.
I'm just saying I think there might be a way to accomplish what we want to
Sir.
do here, but I just wonder what these other states are doing.
I know that Mr. Perdue looked at, so we can get with him. And
Members, any other questions? Okay. Look forward to seeing your proposed changes in writing and to working with you on this. Thank you.